Thank you, Michael, for being patient with my timekeeping. Really appreciate it. Really, he doesn't need any introduction whatsoever. I think known as the godfather of sports law, or commonly known as the godfather of sports law. Years ago, I had the privilege of doing a podcast with Michael. I had the privilege of interviewing also at The Hague, and he once said to me, I said to him, I'd really like to, in this interview, to give people the opportunity to ask questions, because for me, I always found it very intimidating to see him at conferences and all the great stuff that he'd done. And I had all these questions I wanted to ask, but was too embarrassed, and he said to me, "Sean, you are eccentric." And I always thought it's one of the proudest moments of my career to date, to be honest with you. For those that don't know who Michael is, well, I don't think there is anyone who doesn't know who he is. I have to say, in preparation for this, Michael's got a new book that's out, which is his memoir, Life With and Without Law. And I have to say, it's absolutely fabulous. I'm thankful to also say that I didn't read it before we did those interviews, because it's incredibly intimidating. He's had the most illustrious career. He pretty much, from reading this, could have chose to do anything he wanted to in the legal profession. He is an expert, as it turns out, as I've now found out. Not only, also, we know him in our community for being a CAS arbitrator, one of the top sports lawyers, one of the top sports advocates, a judge, a chairman of different ethics committees at World Athletics, IAAF, pretty much ICC, pretty much pick a sport, and we've talked about it internally amongst the team. I'm not sure if there's any sports that you haven't been involved with in a very senior role over your career. But also on top of this, he's been an expert in tax, was involved in some of the earliest human rights cases, has been involved in international disputes, has travelled around. I mean, it truly is breathtaking. I'm not just saying it. I'm not getting any money for this. It truly is worth, if you've got any, I would presume you are interested in law, I'd thoroughly recommend getting a copy of this book. But for the space of time, because it would take a good few hours to go through all the illustrious positions that you've held in your career. One of the things when you, well, first of all, thank you, Michael, for agreeing to do this. I really appreciate it. When I had the privilege of going to your book launch, and one of the things that struck me was the broad experience you had coming into the bar. You're known as being this outstanding legal mind and practitioner. What do you think about the sort of broad range of experience that you had across the different legal areas? So you were doing criminal law, you were doing tax law, had on an influence in terms of your career, in terms of your development and I guess skill acquisition as an advocate?
I don't think there's ever a thing such as knowing too much law. There is a thing known as knowing too little law. What I do think has been helpful is I do think there's a lot of cross-fertilization between the various aspects of law, and indeed the very fact that we discuss sports law and then ask, is it actually an autonomous discipline, or is it actually just the putting together of various ingredients of other recognized disciplines? And the moment one appreciates that there's a force in the second of those two propositions, one can see how valuable it is to be at least somewhat familiar with all of them.
And one of the things that struck me when you started out, I think you said that, and I'm going to get this wrong, I know, but I think you said when you started out in chambers, there was no silks in your chambers, and there was some restrictions on how many silks could be in chambers. And did that have any influence in terms of the exposure of work that you got?
Well, there were all sorts of restrictions at the bar, which people, and indeed the solicitor's profession, when I started, which was more than 50 years ago, which people would find unbelievable now, there was a rule about not having more than 2 silks in sets of chambers, and there were sets in which very eminent persons, I mean, Essex Court, for example, that very well-known commercial set, had to subdivide into 2 because they weren't permitted at that stage to have 2 silks. We started, as I say, when I came in. Just before I came in, there were 3 silks. They all disappeared just when I was admitted to chambers. I don't think there was a causal connection between the two, but one can never be sure. But now, Blackstone Chambers, as it's mutated into, almost half of them are silks. And I think we were 120 persons, at least when I consulted this morning, there were 120. There are probably about 125 now. Who could tell?
And with the sort of the broad experience that you had, and then with coming into chambers without silks there, did that give you more opportunities than you may have otherwise had?
Well, I think so. I mean, because it was a relatively small set, there were less opportunities. I mean, one of the things, of course, I don't say I suffered from, but I had the experience of, was not being taken in to high-profile cases by senior silks, because there weren't any senior silks around. So you very much had to plough your own furrow. Blackstone's two-hair court, as it then was primarily, if I may say so, a second-rate commercial set that hoped to be a first-rate commercial set, mainly because of the late Lord Leicester, Anthony Leicester. It branched into public law, and I think most people would say, although it's very strong in both those areas, indeed many other areas, it is probably best known for its public law and judicial review and so on and so forth. No doubt we know there's a high-profile case going on now about the Rwanda, send them to Rwanda policy of the government. And I was walking down to Chambers yesterday because I was doing a sports arbitration there online. And I passed a series of people. They almost seemed like a sort of busload of persons. And I suddenly realized they were all people involved in this particular litigation. It seemed to me almost half of Chambers had migrated to the High Court. And they were, I think, on the claimant's side. The respondents were represented by my old pupil, Lord Panic, and James Eadie, of course, Treasury Silk. So there it is. That's how it's developed. That's the kind of case that we now have. But in sports law terms, it was pure fluke. And if you ask me later, as you may be proposing to, what's the greatest quality a barrister can have, it's actually luck. And I happened to be at college in Oxford at the same time as someone who became an Olympic silver medalist in track and field. And he formed the first ever athletes pressure group. And they got into some legal trouble about a contest with the 3As, who were the governing body of the sport, as to television rights, which at those days had been assigned to the BBC exclusively. And they set up this new notion of having an international events just bringing in celebrity athletes from outside. So it wasn't team competition, it's one-to-one competition. They wanted to sell it to ITV, and that's where the collision came. So I was regarded, obviously, as a cheap possible counsel and possibly cheerful as well, I don't know. But in any event, after that, my clerks, with the genius which distinguishes that category, were always able to say, sports law, Mr. Beloff's your man. So it snowballed, and because, I did the second case and the third case and the fourth case, so it mushroomed, and that's why I became known as the godfather of sports law.
Just that easy. There we go. So there's hope for all of us then. One of the things is, again, reading your book, you've represented, you've been all around the world representing governments, representing, I think, like Jerry Packer. You've pretty much been there and done it. But the one thing that strikes me, having had the privilege to get to know you over the years, is how passionate you are, even to this day, particularly about athletics, which is the sport that you love, it seems, the most. What is it about athletics that still captivates you?
Well, I regard it, putting to one side issues with drugs and so on, as, in a way, the purest form of sport. I mean, all of us can, to a greater or lesser degree, at various stages in our life, run, jump, and throw. And therefore, you can relate to those persons who do it particularly superbly. That's the first point. The second point is that you can measure success in athletics. I mean, there's no lying. If someone runs faster than someone else, they get to what used to be called the tape, now the beam, or their times are better than other person's times. And also you can see this gradual improvement in performance, which is also very encouraging. So I think those are probably the two main reasons.
And what got you interested in athletics in the first place?
When I was a very small child, there was a series, I think, called something like Adventure and Discovery, and it was kind of slightly upmarket Reader's Digest for children. They had just various different essays on various different topics. And I remember particularly 3 essays on 3 sportsmen. One was Parveen Nurmi, the flying Finn. The other was Spiridon Nui, who was the person who won the first ever modern marathon in Athens. And the third one was a guy called Arnold Strode Jackson, who was an Oxford graduate and who won the 1,500 meters in Amsterdam, beating no less than 4 Americans. There was no limit on teams in those days. And I had the pleasure and privilege of meeting him when he was a very old man, and I was then involved in some way in Oxford, I think teaching on a part-time basis, and having dinner with him. And there was someone, I remember, the page of that book. So that, reading about people like that, I think also inspired me. And I was a sort of modest schoolboy athlete, so it just went on from there.
And why does sports law interest you so much? Because again, as I said, you were known as being a leader. I think in the book you describe it, by Chambers and Partners or Legal 500, whoever it was at the time. I think Chambers and Partners described you, I think, in public law as a top tier, in tax, in all these different areas. What is it about sports law that's so captivated you?
I think I should correct on tax. I think I've been put in categories in 13 separate subjects. As far as tax is concerned, all I do, like the rest of you, is I try to pay it on time with the wherewithal. But I suppose the answer about sports law is precisely because it was not a recognized discipline at all. I mean, I wasn't the first English sports law. There was a marvelous guy called Edward Grayson, who no doubt few of you are old enough even to remember. He wrote a book about sports law. He was the one, whenever something came up with a possible legal dimension for sport, the BBC would call him in, and Edward would, I was going to say witter away, but that's a very unfortunate way of putting it. He had an endless flow of words, not always channeled necessarily in the correct direction, but he was, in that sense, the pioneer. And I think I probably came second in that particular race, but we were developing something that hadn't been there before, so that's why it's particularly interesting.
And I mentioned to you that I had the privilege also of interviewing Lord Dyson, and he said something about, which was fascinating, that he cared to this day, coming to the latter parts of his career, about doing great work, doing work that he doesn't want to make any errors. And I mentioned this to you, and in response you said, "Oh, that's really interesting. I really care about interesting cases." And I was curious at the time about how you would define an interesting case. And I still am.
Well, I mean, I define an interesting case on one of two criteria. I mean, either it's got a new and undecided point of law, or it's high profile in terms of the personalities who are involved. Now, I've got two of my eminent clerks sitting there supervising what I'm going to say. Well, I'm going to say something that they probably know from their own experience, certainly the senior of the two, that for me, the payment was not the main object. I mean, clerks are there to ensure you get the maximum fees, and that's very happy the way they perform that particular function. But there were times when I would actually do a case for nothing just because it was more interesting. Some barristers are only concerned with the amount they earn. Others have perhaps a wider sphere of interest. And I think was in the latter category before I retired from full-time advocacy, after 50 years, which is long enough, I can assure you.
And in sports arbitration, we've obviously over the last couple of days we've heard about the growing acceptance, let's say, or acknowledgement of human rights, and we had Despina obviously articulate that very well from the perspective of the Swiss Federal Tribunal and CAS. What is your take on sports arbitration and human rights?
Well, I mean, sports arbitration has to recognise human rights. It's not some sort of alien substance that you can put to one side. And actually, I think the most interesting CAS case I've ever been involved in was a case where I was the advocate. I was an unsuccessful advocate. This was a case about an owner owning two clubs in the same UEFA competition. And was that or was that not legitimate? And it was a very elaborate decision by three very eminent CAS arbitrators, but they did there mention the human rights aspect, the European Court of Human Rights, the relevance of that. They also were the first case in which this so-called lex sportiva, this notion of an overriding set of principles that sometimes can allow you to disapply regulations that are manifestly unfair and the like. So there it is. I mean, human rights is part of modern law. I suppose there are two aspects I would single out. One, obviously, is procedural. I mean, fairness is regarded now as essential in every area that one can identify, and that has a human rights aspect, obviously, Article 6 of the Convention and analogues in other areas. The other is something you did discuss yesterday, which has achieved a salience that it wouldn't have had 5 years ago, which is the transgender issue, which obviously, again, raises human rights issues. Interestingly, and I checked this with you, Sean, as you know, apparently the discussion was all about transgender, not about intersex athletes, who are a different category, which was an issue that arose very unfortunately with a South African athlete, Caster Semenya, who was, in my view, very badly treated in terms of the publicity she was given, etc., etc. Her case was simply mishandled. But as far as I'm concerned, biology is the key determinant in dividing up competition. I mean, why do we have men's and women's competition? What was the original reason? Well, the original reason was that in many sports, the difference in physiology is what dictates the outcome. And therefore, it's biology that seems to me to be key. And it's no use saying, well, I identify as one gender or another if your biology remains unchanged. And that's a particularly then sensitive issue where there were intersex athletes. First three winners, I didn't need much of the science. I'm afraid I took a commonplace point of view. The first three athletes in the 800 meters in the Rio Olympics were all intersex athletes. It wasn't generally known at the time. It is now known. It seemed to me that the coincidence, it couldn't be mere coincidence. There must be some correlation between the two. And when I was responsible for assisting in drafting regulations for intersex athletes for the Athletics Federation and indeed for the IOC with Jonathan Taylor, QC, very well-known English silk. And what was interesting, we had a colloquy, firstly in Nyon, and there were a series of intersex athletes who came on. And I must say, compared with what I call the transgender lobby, they were remarkably open-minded about it. And they did recognize that there was an issue to be tackled. And they didn't want to close down the discussion, as some, obviously not all, transgender activists do. But those are obviously complicated human rights.
And in that point, though, what's one of the, I don't want to get into like deep conversations about that, but what's one of the arguments, though, if you were saying that obviously intersex athletes, you've got some people who have, genetic sort of makeup where they're 6'7", or there is Shaquille O'Neal who's like a mega athlete, you would say that's one could argue that's an abnormality, right? And you have to address it. Where do you see you should draw the line?
Yes, you're right. I mean, one could discuss this almost endlessly. I think the difference is, if you recognize starting that there biologically are two separate sexes, then these, I don't want to call them anomalies or oddities, I mean, that's a pejorative word, but these differences are the transferring of one biology of a person into another biology, and that's the issue. So obviously some men are very tall, some are very short, some have built-in fluency of movement, others don't, but none of these are taking from one sex the characteristics of the other. That's how I would defend the position of focusing on that issue.
And just before we come to questions, if there are any as well, you've met some very impressive people over the years, whether it's heads of state, whether it's business leaders, whether it's judges. Obviously, you've represented a lot of them. Is there anyone who stood out to you that sort of really impressed you, or you've taken anything from?
I'm going to give you 5 names very shortly. As far as judges are concerned, there are 2. Tom Denning, the former Master of the Rolls, and Lord Bingham, who held all these posts. It's a pity that very few of you, the English people, probably even recollect Tom Bingham, Tom Denning. He was an extraordinary person whose judgments depended entirely on his perception of justice, which is probably a good thing. He overrode a lot of legal principle. He had a magisterial command of English, and he was a delight to appear in front of. Tom Bingham, also huge sense of justice, but a different form of judgment. I don't say that judges nowadays deal in sort of competitive academic analysis, but there is a great deal more case law in the leading judgments than there used to be. So those are those. Athletes, two in particular, both of whom became very good friends. Roger Bannister, because of his range, not merely being the first 4-minute miler, because of a hugely eminent neurologist. And the other is Mary Peters, of whom honours have been showered. I first encountered Mary cheering her late night to success in the pentathlon in Munich, and she did become a friend after. We used to meet from time to time when she was chair of the British team, and I've given talks for her in Belfast. But she's just a great human being and an incredible emphasis and asset to her community. And the last person is someone I sat with, the South African Albie Sachs, the one who lost an arm, a supporter of the abolition of apartheid, who ended up on the first of the Mandela Supreme Courts, but also sat with me when we were debating the spot fixing in the Pakistan team in the Lord's Test match, I think in 2011. And the reason that I admire him is not so much his extraordinary courage, but I remember when we were sitting in Doha, he was already about 75, and he used to take a nap after lunch. He had a little baby who was buying, that was something at his age, having whatever wife it was. But also, although he was a person of huge principle, he had enough what I'd call political judgment to make a slight adjustment. For example, and this is 30 seconds, you may remember there was a case in this country about a baker who refused to bake a cake, I think, for a gay couple because of his religious beliefs. And the Supreme Court said, no, God, it's across the board, this principle. Albie in South Africa took a different view. He said, look, how many people are there really, for religious reasons, aren't going to do something like that? There are plenty of other people who are happy to bake a cake. So he was prepared to make a sort of practical exception. And I think that also showed a certain amount of courage. But he was just a great human being. So that's my quintet.
Thank you. Do we have any questions? Have I got the thing, or where's it gone, the cube? Who's got the cube?
Dan Kirchlechner from FIFA. Firstly, thank you very much for your inspiring words. I just wanted to ask whether you recall the name of the decision in which, or not you personally in the decision stated, but the Cass Award, which you said that human rights can trump regulations which are not necessarily reasonable. Or
it's the so-called Exportiva. Yes, it's called AK Athens and Slavia Prague and UEFA, I think. And I think it's in the first volume, edited by Mathieu Rabe of the Cass reports, or maybe the second one, about 98.
98, 200.
There you are.
There you go.
There's a scholar.
There you go.
A scholar. You're
You
quite
can have
right.
a star.
That does ring a bell. Yeah.
Well done. I'm impressed.
thank you.
What, up the top, Ben? Great throw.
Benoit Keane, based in Brussels. Michael, absolute pleasure to hear you speak and give such wonderful insights, and I look forward to purchasing the book.
Good.
I'll find out where to do so before I leave. But my question is, you've had an illustrious career both as an advocate as well as a Cass arbitrator. What is the one tip you would give to those of us who are advocates when you're presenting a case? What is the one golden rule you would try and apply to become a good advocate?
Well, obviously preparation. I think the most important thing for me, for an advocate, is to recognize what's relevant and what's irrelevant. It's not true that there's only one point in any case, but there is usually a major point. So focus on that, discard the peripheral material, never interrupt the judge or arbitrator. And in terms of your submission, in particular now we have so much written advocacy to complement oral advocacy, the best written advocacy submission you can make is one that the judge could easily adapt into his own decision, or indeed the arbitrator. In other words, they just simply take it, they give a little tweak to make certain that people don't think they purely plagiarize it. That's the objective. That's the objective.
That's a great tip.
Thank you, Mike.
I think we'll go out the back, and then since it's over that way, then we'll come round. Did you want one as well? Yeah. We'll come. Yeah.
Hi, Anand Patel. My one question to you is, the number of illustrious roles and titles you've held over your 50-year-plus career. Which role or title was your most enjoyable, and why?
Well, it's one that hasn't been mentioned. It's not particularly important for a colloquy of sports lawyers. The thing that I enjoyed most, if I had to ask at the end which, if all of them, and indeed that's the question you asked, I enjoyed most, it was being president of Trinity College, Oxford, between 1996 and 2006, when I took not complete time off, but certain amount of time off from sport. And I just enjoyed the experience of trying to have some kind of influence and present some kind of model to young people. If I can just add this, an anecdote. A couple of nights ago, Freshfields, who were the legal firm particularly involved in the promotion of London 2012 Olympics, held a party for the lawyers who'd been involved. And I'd been the ethics commissioner for the bid, so I was invited to that. And I met a young woman there who was a student of mine, a young woman student, and it was lovely to see her, and she had been, in fact, part of the bid process as well, though I was ignorant of that. She's now legal advisor to the Welsh Rugby Union, and I thought, there we were. I remember her, struggling with the second year exam in tort or something. I mean, she obviously did very well, but there it is. They are now doing serious work in major institutions, and many of them actually in sports law.
Wonderful. I think we're going to go that way and then come down here. There was a question over here, down here. Just sort of work its way back round this way.
I've never seen these before. It's much better than the roving. I thought for a moment...
Joe, I'm glad I was worried if he was going to get your approval or not.
I'm so untechnical. There isn't a microphone in there.
There is.
There is a microphone.
There is.
Oh,
there you go.
It's not... Yeah, that's all there is in it. That's fine. Yes, sorry.
It's okay. Thomas Horton, barrister at 3 Hare Court Chambers. Besides look and chief rates, for somebody who's at the beginning of their career at the bar or the first 5 years, what sort of one piece of advice or one key tip or tips would you have for somebody looking to build a sports law career at the bar?
Yes. I mean, this is an absolutely standard form. You join, if you may, Sean's organisation, you join the British Association for Sport and Law, you network as much as you possibly can. If you're interested in writing, I still edit Sweetens and Maxwell's International Sports Law Review. We're always interested in contributions. So have a go. I can't guarantee what, but that's the best way of doing it. There isn't actually any other obvious way.
Do you want to go across or to safer bet? Oh, yeah, great catch.
I'm Marcello, law student. I have a simple personal question. You just said that years ago, sports law was not a field that was recognized or studied. And now we see in many, many universities in the world that is being studied and very, very, very seriously. What do you feel about it?
Well, that's...
You're a gentleman.
It's obviously, I don't know, as it were, which comes first, the chicken or the egg, the emphasis in university courses or the practical world. I think they interrelate to a certain extent, but obviously it's a very good thing. I mean, I once taught what was laughingly called a course in international sports law in Tulane University in New Orleans, which I went to because I wanted to go to New Orleans. But there were two peculiarities about it. First of all, I was told in an American law school, you have the Socratic method. So what you do is you, rather like Sean's been doing here, you pose a question and someone comes back in dialogue, whereas in England, lectures are given to a sitting or possibly standing audience. I discovered that wasn't true at all. No one had the slightest interest in entering into dialogue with me. So I had 8 separate sessions where I had to produce a lecture of about 40 or 50 minutes. The second thing that I was impressed by was I was told the grades that had to be given. I mean, a certain amount had to be within that block, certainly within that block, and certainly within that block, irrespective of my view of the merits of the particular students. Most of them were going to go, I mean, they were all interested, I think, basically in going into sponsorship, the sort of lucrative side of sports laws, or whether I assisted them in that regard or not, I don't know, but I much enjoyed New Orleans, and I much enjoyed the peripheral activities there.
One of the things you said in the book, which I thought was quite interesting, that you said that all of the, it was cheap travel, basically, to do with this. I think that was, you had a great ticket or something. It was a first...
Oh, coach, oh no, that's right. I didn't know what the word coach meant in terms of travel class in an American airline.
Alexander Engelhardt.
I know who you are.
Talked outside. I'm a private practice lawyer from Germany, and I used to work with another great CAS arbitrator, Rainer Martens, and he wrote an article in the CAS bulletin some years back about the role of a CAS arbitrator in sports arbitration proceedings, especially the chairman. If you would have to name top 3 skills that an arbitrator should have, especially the chairman, what would they be from your perspective?
I've got 2 very eminent chairman colleagues sitting almost in front of me who are better equipped, no doubt, than I. Anyone who sits in a judicial or arbitral capacity has to be patient. In other words, you must do your best not to seem to prejudge the issue, even if you have a very strong view before the case has even been heard. You've got to be patient with the advocates, but you've equally got to exercise control like Sean has done here, masterfully until the last episode. No criticisms. You're allowing me to overrun now in any event. But you have to exercise some control. I mean, there should be a timetable and so on and so forth. And I think you've also got to be collegiate. I mean, that's to say you have to be able to swap ideas. You can't always persuade. I mean, there are dissents, as you know, in CAS, but all they're recognized as being dissents. You're not actually allowed to have a dissenting opinion. I once, in the other area, was the International Cricket Code of Conduct Commission disciplinary body. I raised an issue, actually, as to whether or not it was proper to prohibit dissenting opinions, whether there was some kind of principle. And the advice I got was that, in generally the international arbitral world, it's regarded as desirable, but it isn't actually mandatory. For my part, I actually would welcome the having of dissenting opinions, that I think it enriches. I mean, after all, the majority may be wrong, and next time round, especially since a binding precedent, someone may be influenced by them. Why not? But CAS, as I think we all know, is quite controlled, as it were, from the centre, and without interfering with the way in which decisions are reached in any oppressive or other way. They've got their way of doing things. Whether that's going to be the way they do things forever, who knows?
Are you happy to take one more question?
Yes.
I
wasn't
quite sure if I was getting told off or
We're
not.
getting a drink afterwards. I'll have had my 3/4 of an hour for what it's worth.
Jack Willis, Student Union of Sussex. Bit of pressure now being last question, but what would you say is your greatest achievement in your career?
Well, I mean, I suppose in one sense you might say being president of Trinity College, Oxford. I've already answered that. In sports law terms, and this is something I do mention in the book, I was the barrister for Christina Hurugou, who won the 400 meters gold medal for women in the Beijing Olympics. And she had actually been disqualified on the basis of 3 times and you're out by the British Olympic Association. And I had to appeal that to a domestic panel, and she succeeded. And I had what I think may be an almost unique, if not unique, experience of sitting in the bird's nest in the Beijing arena and watching my client win Britain's only gold medal on track and field when she wouldn't even have been in China at all. but for the support and the forensic support that I gave her with, in fact, my son, who's here's my second junior. That was pro bono work we did. It was worth every penny, if I can mix, as it were, the metaphor. And Christine has become a good friend and is now herself qualified as a lawyer, and I suspect will be a very good one.
And it was, yeah, and it was because of you, yeah, the work you've been doing. Well, thank you for that. Unless there's any other burning questions. Michael, I don't think it's an impossible task and honestly a very daunting task to do this, but I really felt that, you know, one, you're a gentleman, an absolute gentleman. You've tolerated me for a while now, which is something in itself. But in all seriousness, that you've been so encouraging to so many people, and I think your answer about your work at Trinity it exposes, I guess, how you view the world and the legacy you're leaving for us to take charge of in, I guess, in sports or to build on the excellent work that you've done. Thank you for being compassionate and kind to others and helping people like me and others to progress in this sector. It's something I greatly appreciate. It's been a real honour to have you here at our conference and speak. It is something that matters a lot. And I'd say I'm a lot of flattery to people, but to little minnows like myself coming through the space, people like yourself, taking time to have a chat and be supportive, do a podcast here and there, meant the world to me at the time. So thank you very much. It's been a real honour and privilege. Please give Michael a round of applause.
I'd like to thank you, Sean, for inviting me. You've done a remarkable much in sports law field, as this kind of conference shows, and it's by no means unique to what you've done. One person did ask a question, rather optimistically, suggesting he might wish, maybe not on second thoughts, to buy the book, and he asked, how do I get hold of it? Bloomsbury website is the way that you can get hold of it.
And you can go to the link on on the events page. You can go to the link. We'll circulate it. It should have been circulated. I did promise you, and I'll just
after the event.
No. But no. It should have been in the link to all the emails you received. It should have been hyperlinked. If it's not, we'll remind people to get that. And in fact, I think if Gabriella's in the room, we've got a 20% discount for all attendees as well.
Frankly, I mean, I Google the title almost every day just to see if anyone's picking up something or other. So if you do Google, it'll also give you a certain amount of information.
It'll be in the post-attendee email.
It will be. Fantastic. Great. There you go.
It really is.
Let's all have a drink.